हेलो, वेलकम यू ऑल टू LawSikho। तो आज हम दो इम्पोर्टेंट टॉपिक्स के बारे में बात करेंगे। रिसेंट टाइम में काफ़ी ज़्यादा न्यूज़ में रहे हुए हैं। बहुत लंबे टाइम से अगर हम देखें तो इससे रिलेटेड सुप्रीम कोर्ट के केसेस भी रहे हैं और अदर केसेस भी है। ठीक है, लेजिस्लेटिव रिफॉर्म के लिए काफ़ी लंबे टाइम से डिमांड थी दोनों ही आज के इश्यूज़ में। तो एक एक करके हम दोनों के बारे में बात करते हैं। जो आज का हमारा सबसे पहला टॉपिक है दैट इज़ रिगार्डिंग बैन ऑन ऑनलाइन गेम्स। एज वी ऑल नो, ठीक है, जो फैंटेसी गेम्स होते थे, ड्रीम 11, माई सर्कल, रमी एटसेट्रा एटसेट्रा, दिस ऑल आर नाउ बैंड। ठीक है, पार्लियामेंट रिसेंटली पास्ड अ लॉ। The name of the law is Promotion and Regulation of Online Gaming Bill 2025. ठीक है, it establishes a legal framework, ठीक है, to promote e-sport and social gaming, while on the other hand it banned all money-based online games. So we are just listening only one part, that is banning of online games. But with that, by this particular bill, one more thing is done, that is promotion of e-sport and the social gaming. अब इसके पीछे रीजन ये बताया गया कि जो ऑनलाइन मनी बेस्ड गेम्स हैं, इससे कहीं ना कहीं फाइनेंशियल हार्म हो रहा है। ठीक है, एडिक्शन बढ़ते जा रहा है बिकॉज एडिक्टिव एल्गोरिथम है, और रिस्क इसको लेकर काफी ज्यादा हो सकती है रिगार्डिंग टू कंपल्सिव बिहेवियर। अब अगर हम बात करें इस बिल की, तो क्या क्या चीजें इसमें प्रोहिबिटेड है। बैन ऑन ऑनलाइन गेम्स, ठीक है, जिसमें मॉनेटरी स्टेक हो, वेदर इट इज फीस, डिपॉजिट्स और वेजर। ठीक है, तो यहाँ पर किसी भी तरीके की चीज को छोड़ा नहीं है, एग्जॉस्टिवली सारी चीजों को कवर कर लिया है। इधर इट कैन बी इन द फॉर्म ऑफ फी, डिपॉजिट, वेजर। जहाँ पे मनी स्टेक पर है, इन एनी ऑफ द फॉर्म, दैट विल बी covered. Now it will applies to skill, chance and both. Okay, so prohibit the activities including even if somebody is offering, facilitating, advertising or even the participating. ठीक है, सो यहाँ पर भले ही वो गेम ऑफ स्किल हो, चांस हो, या दोनों ही, दोनों का कॉम्बिनेशन हो, भले ही इट इज रिलेटेड टू ऑफरिंग, फैसिलिटेटिंग, एडवर्टाइजिंग और पार्टिसिपेटिंग। ठीक है, एवरीथिंग इज कंप्लीटली कवर्ड अंडर दिस प्रोहिबिशन। Now, if you see certain examples of this, fantasy leagues, तीन पत्ती, rummy, poker, ठीक है, betting, gambling, all are covered under the prohibition. Now, what thing will be allowed or promoted by this particular bill? So, the e-sports. Now, e-sport you must have heard about in the Asian Games also. ठीक है, जिस e-sport में आपका mental and physical, ठीक है, यहाँ पर दोनों एबिलिटीज यूज हो रही हो, वैसे स्पोर्ट जो है दैट विल बी अलाउड एंड इवन प्रमोटेड। ठीक है, सो इट इज रिकॉग्नाइज्ड एज अ लेजिटिमेट कॉम्पिटिटिव स्पोर्ट। ठीक है, एंड इट विल बी सपोर्टेड थ्रू सर्टन गाइडलाइंस, ट्रेनिंग एंड इंसेंटिव्स। ठीक है, फॉर एग्जाम्पल, if we talk about the e-sport Olympic event which will going to happen in Saudi Arabia in 2027, ऐसी चीजें उसमें कवर्ड हैं। ठीक है, ई स्पोर्ट फेडरेशन, वी हैव ई स्पोर्ट फेडरेशन ऑफ इंडिया ऑल्सो। ठीक है, वेरी फ्यू पीपल न्यू अबाउट दिस। ठीक है, सो इट शुड बी डिफाइंड, सो इट विल बी डिफाइंड बाय ESFI and it should not be confused with the casual games or the gambling. ठीक है, so this game is played for the fun without any money on the stake, तो जिसमें मनी इन्वॉल्वमेंट नहीं है, that will be allowed. Now penalties जो है, penalties काफी ज्यादा heavy है। If you are offering any online games, then there will be imprisonment of 3 years, fine up to 1 crore rupees. Repeated offense अगर आप करते हो तो the punishment will be 5 years and the fine will be up to 2 crore rupees. Okay, then if somebody is advertising or promoting it, ठीक है, so for example BCCI, ठीक है, given the sponsorship to Dream 11, now BCCI is directly indirectly promoting or advertising it. ठीक है, अगर आप ऐसे करते हो, now after this ban then there will be imprisonment of 2 years and fine up to 50 lakh rupees. Repeated offense के लिए it will increase to 3 years and fine up to 1 crore of the rupees. Even अगर जो फाइनेंशियल ट्रांजेक्शन में अगर आप ऐड करते हो, if you are a bank financial institution, then again here also there will be punishment of 3 years and up to 1 crore of rupees. And for enforcement of this particular thing, ठीक है, what enforcement powers will authorities have, that will be regarding the search and the seizure, whether it is physical or any digital asset. ठीक है, and arrest without any warrant if reasonable suspicion is exist. ठीक है, so non warrantable भी without any warrant also a person can be arrested under the bill if there is a suspicion. Now there is a इंटरेस्टिंगली देयर इज अ पॉलिसी शिफ्ट बिकॉज 2023 में गवर्नमेंट ने आईटी रूल्स के अंदर ऑनलाइन रियल मनी गेम्स को परमिट किया था, ठीक है, एंड दैट वर सीन एज अ प्रो इंडस्ट्री ऑफरिंग द पॉलिसी सर्टिनिटी। तो यहाँ पे कहीं ना कहीं गवर्नमेंट एक पॉलिसी सर्टिनिटी लेकर आ रही थी रिलेटेड टू दिस ऑनलाइन रियल मनी गेम्स, but all of sudden now we can see in 2025 there is a blanket prohibition on this type of games, and there is no any distinction between game of skill and game of chance. Earlier in the IT rules it was there. Now game of skill versus game of chance, what is the legal position that we have? If we see article 191G of the constitution that gives the right to carry on any trade and occupation. Okay, now courts have held previously that in various cases that game of skill are legitimate. Okay, but the game of chance that are not legitimate. So game of skill are legitimate business activities and cannot be equated with gambling. If we see 1967 में the very first time Supreme Court have given the ruling related to rummy, they said rummy is not gambling because predominantly and mainly it is based on the skill. Now Andhra Pradesh, this particular case was related to Andhra Pradesh anti-gambling law. ठीक है, sorry, this Andhra Pradesh anti-gambling law. So this particular precedent will not be applicable to Andhra Pradesh anti-gambling law. So there was an exception in that. Okay, now second was in 1995 that is related to video games. So it was classified as a gambling since the result could be manipulated by machines. So video games as imagine 1995 में आज से 30 years ago, ठीक है, वीडियो गेम्स को जो था माना जाता था कि दिस द रिजल्ट कैन बी मैनिपुलेटेड. So therefore they classified under it gambling, ठीक है, and skill not predominant factors. So 1995 में all together in last 3 decades we have seen a huge shift and the change in the perspective for pursuing especially the video games. Now if we talk about horse racing, so horse racing is a skill of game and outcome is totally depend on breed, form, ठीक है, jockey skills and the race course conditions. So betting on horse races not covered by Tamil Nadu gambling law. And last now we have this fantasy sports and Dream 11, in which High Court High Court and the Supreme Court given the ruling that fantasy cricket is a game of skill and therefore it is not gambling and it should be allowed. So success is depend on the knowledge, analysis and the judgments and not on the outcome of a single match. Now if you see the state laws, so betting and gambling, okay, this particular entry comes under the state list, the list 2 of 7th schedule. So state can make the laws regulation related to this. Now most distinguish the game of skill that is permitted versus game of chance that is prohibited. ठीक है, तो जनरली इंडिया में ये रहा है कि एक डिस्टिंग्यूशन हुआ है, एक डिफरेंशिएशन हुआ है बिटवीन गेम ऑफ स्किल एंड गेम ऑफ चांस. गेम ऑफ स्किल्स को जनरली अलाउड करा हुआ है, गेम ऑफ चांस को मोस्ट ऑफ द केसेस में प्रोहिबिट किया है. कुछ जगह ऐसा भी है जहां पर दोनों का ही कंप्लीटली प्रोहिबिट किया है. नाउ विल सी स्टेट बाय स्टेट व्हाट लॉज वी हैड बिकॉज इट इज द स्टेट लिस्ट सब्जेक्ट. नाउ Sikkim 2008 the first state that regulated and given the license to all forms of online games and betting that includes 13 games plus sports betting. Now restriction was given on the games only at the particular restriction was that these games have to be carried out on a designated gaming parlors only. Now after 2008 it was in 2015 when Nagaland given the license to online games of skill. So they have recognized 23 categories. Okay, after that we have Chhattisgarh in 2023. So Chhattisgarh banned almost all the gaming, all the online gambling and the betting, and they excluded the few games that were based on the games of skill. Then we have in Telangana, Andhra Pradesh and Karnataka. So Telangana in 2017 first they ban all the online stake based game जिसमें money involvement is there, and that was followed by Andhra Pradesh, Karnataka and Tamil Nadu also. 2020 में Andhra Pradesh, 2021 में Karnataka and 2022 में Tamil Nadu. Now what are the judicial pushback or judicial precedent we have? Now pushback why? Because judiciary time and again recognize this thing कि game of skill, banning game of skill should be unconstitutional. This thing was happened by the Karnataka High Court in 2020, because Karnataka government came up with the law in 2021, and all in the very next year, Karnataka High Court said this law is unconstitutional, violates Article 19(1)(g). Then Madras High Court also partially struck down the Tamil Nadu law. Okay, and game of skill cannot, again they have reiterated the same thing that Karnataka High Court said, that is game of skill cannot be barred. And Kerala High Court also in 2021, they quashed the ban on online rummy, and they have referred to the Supreme Court 1967 judgment that said rummy is the skill game. Okay, now interestingly, what impact it will make on our economy, because the concern is the red flag that is raised, that is regarding the economic and the revenue loss. If we see the market size of this online fantasy games or online money games, it is $3.7 billion, and by 2029 it was projected that it will increase up to more than $9 billion. Just imagine the size of the market, and how many people were employed in that. So 1 lakh jobs were there in 2025, and 2025 the expected was 1.5 lakh people will be involved in this particular industry. So if we see that revenue, how revenue comes to this company, so 86% is from the real money gaming, the people who put the money. Okay, and majority of the transaction was happened via UPI only. So UPI ke numbers when we see, so one of the contributing factor was this online games also. If we talk about the tax contribution, more than 20,000 crore directly indirectly taxes. Okay, together if you see, more than 20,000 crore annually tax contribution were done by this online gaming, online money gaming sites or the sports. Okay, so almost there will be the loss of GST, that will be around 50,000 to 20,000 crore. Okay, a huge loss, but government have prioritized it on the basis of public health. Why public health? It affect the mental health, the financial loss to the public. Okay. Now the second topic is regarding center is planning to propose a amendment that can remove the ministers, the minister who are imprisoned. Okay, so what is the proposal of the center? So they are proposing a constitutional amendment in Article 75, 164 and Article 239 AA. Okay, that is regarding Union Council ministers. Okay, 164 is regarding state council minister, and 139 AA, it is regarding ministers of union territories. So what is the proposal? The proposal is that if any minister is arrested and detained for 30 consecutive days on the charge of a charge of an offense which is punishable with more than 5 years of imprisonment, then it will be obligation on the president to remove that minister on the 31st day on the advice of prime minister. And same is the case with the governor also. But the minister which is removed, he can be reinstated if he is released from the custody. Now what is the rationale behind that? What is the statement of object and reasons behind that? This statement of object and reason is that it ensure this particular amendment, after this particular amendment, it will be ensure that constitutional morality and good governance will be on the place. Why? Because the ministers who are arrested on the serious charges, they kind of obstruct the governance. Okay, and it is also proposed, the reason, the rationale is given that it will protect the public trust in the constitutional institutions. Now interesting thing is that if we want to do any amendment of this kind, there should be 2/3 majority in the parliament. Okay, so for passing this amendment, there should be at least 2/3 majority of member present and voting in the parliament. Okay, so by special majority we can pass this particular bill. Now what is the current law? So the current law is that if any person, if any representative, if he is convicted for offense, the punishment for that, the punishment is 2 or more than 2 years, then he will be disqualified. Okay, disqualified for being the member of the house. Now this particular provision is in Representation of People Act section 8. Now this particular provision is based on the principle of due process of law. The charge is proven in the court and then disqualification. It actually emphasizes on the principle of presumption of innocence in the constitution scheme. But related to that, there are two kinds of the view. The first view is that regarding this particular proposed amendment, the view one is that early disqualification is needed. Why? Because if we wait until the conviction, then actual the purpose is defeated. Okay, and even the Law Commission in 1999 in their 170th report, they suggested that a person can be a minister can be disqualified at the framing of the charges for the offense with up to 5 years imprisonment. So for any offense जिसमें 5 year या 5 year से ज़्यादा punishment है, ठीक है, और इसमें अगर framing of charges हो गए, so on that basis disqualification can be done. Again in 2004, Election Commission reiterated this, and again Law Commission 2014 in their 244th report, they have reiterated this particular thing. Now there is one more view that is regarding that actually supports the argument of protecting the due process. Why? Because disqualification, if it disqualify any member of parliament or legislative assembly, it affects the right of the legislator as well as the right of the electorate. Electorate's choice. It also goes against the principle of natural justice. Okay, we know the principles of natural justice. One of the principles is order alterum partem, that is fair opportunity to be heard, and it can be given in the due process of the proceeding only, in the process of the proceeding, okay, or in the trial only. Now, Law Commission rejected the earlier state charge sheet file and court taking cognizance. They said it should be on the framing of the charges. Okay, so because in the early stages there is no any application of judicial mind. Okay, and it will this particular proceeding is a kind of a penal punishment to the legislator. Now, whether there is any judgment regarding this, so answer is yes. In 2018, the name of the case is Public Interest Foundation versus Union of India. A PIL was filed to sought disqualification at the framing of charges for the serious offences. The court held that, okay, so the PIL says that if there is a framing of charges against the minister or any representative, that person should be disqualified. This was a public interest litigation. Now, what court said? Court said this can't be. So court cannot legislate a new ground. Okay, only parliament have the power to make such kind of a law. Okay, and they only they have the power to make the laws related to disqualification. Now they made a recommendation to the parliament, okay, to come up with a strong law to address such kind of a thing. And also they said there should be revocation of membership by the political party, and political party should not give ticket to such candidates whose names are already there associated with certain kind of offenses. There is one more case that is Manoj Narula versus Union of India 2014 case. So the case was that the case held that no constitutional bar against the appointing person with the criminal antecedent and as a ministers. Okay, so in this particular case, again the facts was that a person should not be elected or should be a member of the house if there is an antecedents. Okay, so court said there is no any constitutional bar. Okay, but they made the observation that PM as a repository of constitutional trust, he should appoint only those minister who have a clean background without any criminal antecedent. Okay, and especially he should focus on those persons who are involved in any heinous crime or corruption. Those kind of persons should not be ideally appointed by the prime minister. Okay, and we have two recent cases that was referred by the minister when he was discussing regarding this particular bill, okay, or the proposed bill. So the first case was regarding Tamil Nadu's cabinet minister, that is V. Senthil Balaji. He was arrested in 2023, okay, and he was in custody for 14 days. Now, for being continuously in the custody, okay, finally he resigned from his cabinet ministership. Now, in 2024, bail was granted to him. Now, when bail was granted, he was not the minister, but the moment the bail granted to him, he was reinstated as a minister. Now, prosecution objected this particular thing. He said, court have given the bail, and after that he became the minister. Now he is in the influential position. He can tamper with the evidences. He can also manipulate, or he can also deter the witnesses. Now, when court took the cognizance, court said कि when you asked for the bail, you were not the minister. ठीक है? The moment you got the bail, you became the minister. And this particular fact was concealed to us at the time of granting of bail. ठीक है? So, court given the option, either took the option of bail or resign the post. So they just said freedom or post. Okay, and one more case we have of Arvind Kejriwal, the sitting chief minister. So it was very first time a sitting chief minister was in the jail. So during his complete time till the bail, okay, he haven't resigned from his particular position. Now, interestingly, Supreme Court have restricted, put him certain restriction on him, that he can't sign any files, he can't enter his office, and he can't contact any witnesses. Now, obviously, if chief minister will not do these things, how a government will work, how decision will be taken. So this was the question that was raised. Okay, so therefore this particular two matter were referred by the home minister. Okay, while proposing this particular bill, so he showed the concern regarding this particular bill. Okay, while justifying or giving the rationale of this particular bill. So this is all for today. Thank you so much for listening me. Stay tuned to LawSikho.